All right, so officially, good morning. Are you ready there, Cindy TV? All right. So my name is Dan Costello, and I'm the Public Information Manager for Rent Control. We have 4 departments: administration, public information, a legal department, and a hearings department. And we'll talk about specifically more what the hearings department does with respect to petitions and things like that are filed with our office. But so I'm here with Micah Michalski, and he is one of our information coordinators, soon to be an information analyst. And he is one of the team of people who answers calls from landlords and tenants whenever you've got a question. So we have dedicated staff. You just call us directly, unlike the rest of the city, which relies on a 311 number to access city services. We have our own dedicated phone line, which you'll see at the end, and you'll get connected with somebody like Micah right away, and you can ask your questions. So that's a great resource. So today we're going to cover a lot of different things. We talked about CIVICS, which is our online portal for filing registration forms and that sort of thing. I will hold off on that demo until later so that if more people show up, they can see how to use it, because it's a really useful tool and it allows you to stay in compliance with the rent control law, because there are various registration requirements. So we'll begin with an overview of rent control, what it's all about, the registration requirements that I just mentioned, how we look at what is the maximum lawful rent. That's the amount that you cannot exceed to your tenants. We'll talk about how tenants can file petitions and complaints. So there's also some petitions that landlords can file, and we'll talk about those. And then the eviction protections. We're not going to go over the state of eviction moratoria. It's too complex, and most of those have already ended, so we'll skip on that. And then limitations on the change of use for rent control property. Basically, if it's a rent control property, it stays a rent control property, except for a couple of things that could happen. And that's all part of what the rent control law does. It protects rent-controlled units themselves. We will stop occasionally after each section for questions, and we would just ask that if you have a question, you kind of ask something that's of general interest. If you have something that's very specific to your situation or a situation you're in with a tenant, it might be better just to call our office and talk with somebody directly about that, so we can give you more one-on-one answer. If you're wondering, the restrooms are out the door. Take a left and take a left. There are snacks in the back there. Feel free to get up at any time. You know, it's not going to interrupt us. It's fine if you want to just get a snack or go to the restroom. So with that, I'll just go to things that we aren't going to cover today. So there are many, many things that relate to the landlord-tenant situation that are not covered by the rent control law. And we at the Rent Control Agency are really focused on providing information about the rent control law. If it's something that refers to state laws or other things in the municipal code, you can expect that we're going to give you a referral to another department that can answer those questions, because although staff may know about state laws and municipal codes, it's really not our position to talk about those things, and sometimes there are nuances and it's better to talk with the experts. So among those issues are things like the return of the security deposit. So that is not covered in the rent control law. I will mention, because I don't think we have a particular slide on it, but there is a change coming in state law that will take effect July 1st, and that limits the amount of a security deposit to 1 month's rent. Currently, under our law, you're allowed to collect up to 2 months' rent for an unfurnished apartment. But because the state was concerned about housing accessibility. They wanted to lower the cost of entry to start renting a unit, and that's why there's going to be a new law limiting the amount of the security deposit. We're also not going to talk specifically about the right of a landlord to enter a unit, because that is something that's also covered by state law. There are only certain reasons for which an owner may enter a unit. Once you've leased the unit, the tenant has a possessory right to that unit, and there are really only a few reasons why an owner could enter, and that's basically necessary or agreed upon repairs. And of course, if there's an emergency or something, that would be a reason to enter as well. But there are noticing requirements. You'll see noticing is also up there. Noticing can kind of refer to a couple of different things. One is the notice to enter the unit, and then another notice would be to increase the rent. So if you want to increase the rent, but we'll talk about how we do that every year and the form that is used to do that. But how that notice is actually served is not something that's covered by the rent control law. It's covered by state law. We'll go over the eviction procedures. The rent control law does limit the reasons for which you could evict a tenant, but the actual process is something that happens in court. And as we'll talk about it, but there's just a filing requirement with us, but otherwise everything happens outside of our agency. We're not involved with evictions. There is a great publication, and earlier we pointed out where you can go to information by subject on our website, and there is a link there to California Tenants, a guide to residential tenants and landlords' rights and responsibilities. And that's a booklet that covers a lot of these state laws that we're not covering here. And it's a great resource because it's written in just kind of plain language. And then there are citations to the civil code in footnotes on each page. So if you really want to go and look at the actual law, you can do that for more information. And the California Department of Consumer Affairs also has a hotline that you can call and get information from them regarding state law issues. And if you call us about something that's under state law, we're probably going to refer you to them. There are also things that are under the municipal code that are separate from rent control. Among those things are permanent and temporary relocation. We'll talk more about that later. Building code violations, smoke-free residential ordinance. There are other things like the minimum lease term for a unit is supposed to be for 1 year. But all these things are under the municipal code, not under us. And so generally we would refer you to the city attorney's office for information about things that are under the municipal code. Okay. So this is the CIVICS presentation. We'll just skip over that for now. And I don't think there are any questions yet because I haven't presented it. So introduction to rent control. So I like to think of the rent control law as a chair with 4 legs, and each one kind of supports the law, and each one is important for keeping it upright. The first thing, as the name suggests, is that all rent increases during a tenancy are controlled. So in most cases, we'll talk about it, it's if you have a vacant unit, you can rent it at whatever the market will allow. But then once it's rented, the rent control law limits how much that rent can go up year by year. And we'll talk about the formula for that. And again, the noticing for increases like that. There are also remedies. So another leg of that, of the law is if an owner charges excess rent, or if there is a maintenance issue that is neglected, or amenities are taken away from tenants, then they can approach the Rent Control Board for an administrative remedy. We'll talk about those. It's also possible for an owner to file a petition for rent increase. And again, we'll give you more details on that, but that's a case where an owner's not making a fair return, and under the rent control law, owners are entitled to continue to make a fair return. So if well, we'll talk about how that works out. But and then there are eviction protections, as I mentioned. So if we didn't have eviction protections, then an owner could simply evict a tenant and raise the rent to a market rate. So that's why that's an important part of keeping people in their homes. There are very limited reasons. Most of them, what we'll talk about, most of them have to do with something the tenant does wrong, but there are some reasons for eviction for which an owner can evict even if the tenant is not at fault. And then the last thing is the protection of the units themselves. So rent control doesn't allow an owner just to say, well, I'm not, I don't want to rent anymore. There are some state laws that can be utilized to go out of the rental housing business, but there are a lot of restrictions around that as well. So generally, units that are subject to rent control remain subject to rent control unless there is some official removal or withdrawal of the units. So the question is, what units are subject to rent control? It's not every unit in Santa Monica, as some people think. It's really units that were used for a residential rental purpose on April 10th of 1979. So that is when the rent control law came into effect. So we just celebrated the 45th anniversary of rent control. Buildings built after that date are generally not subject to rent control. There are a few exceptions, but most of the new construction you see around the city is not subject to rent control. So there are some exceptions to what's under. So it's, well, let me first add the accessory dwelling units are an exception to the 79 rule. So if an owner builds an accessory dwelling unit on a rent-controlled property and builds that unit out of conversion of rent-controlled space, which does include a garage, then that new unit would be subject to rent control. And there is a petition that needs to be filed to register that unit with us. But it is a requirement to register it. We see a lot of these ADUs being built in the city, and we are following up as these units come online and getting in touch with property owners like yourself and saying, okay, you need to register that unit. There are some units that are not subject to rent control, and those are single-family homes, particularly those that were not used for a residential rental purpose on a specific date in 1984. If it wasn't used for rental on July 1st of 84, then an owner can file a declaration to that effect, and the unit is exempt. So we won't control the rent. It basically ends our relationship with that property. There's also an opportunity to get an exemption from rent control if it's a single-family dwelling and the owner's been living on the property for 2 years. Then they can just submit an exemption application. It should be fairly straightforward. The board, it does go before the rent control board, and they decide whether or not the unit qualifies for the exemption. And then we have the largest category of units that are exempt are properties with 3 units or fewer. So if the owner lives on the property and has at least a 50% interest in the property, then they can get an exemption for as long as they live on the property and continue to own at least 50%. So if you look at the map, this is a map of the controlled units in the city. They're color-coded by the different city areas that we track in terms of reporting the rents. But you'll see, like in the north east corner of the city, there's a lot of single-family dwellings, and so that whole top part there they're just really no rent-controlled units. Similarly, like in the Sunset Park neighborhood, where a lot of single-family homes, we don't have any. And in the downtown area, there are not that many long-term, like 1979 buildings left, and so there are not a whole lot of controlled units in the downtown area. So most of them are spread around Mid-City, Ocean Park, Pico corridor, like that. So we talk about those properties that are exempt from rent control, but then there is also another category under state law where the unit isn't exempt, but we don't have any control on the rent level. So if it's a separately sold condominium, and the tenancy began after January 1st, 1996, then we don't control the rent. And the tenant would still have eviction protections because this state law that said you can't control the rent didn't take away the eviction protections. But in reality, under the municipal code, many units in the city that are not subject to rent control also have eviction protections. And there are some limitations under state law as to how much the rent can be increased. Again, we don't really talk about those. We'll talk about rent-controlled units. So just keep that in mind, that there are some separately sold condominiums that we have no control over the rent. Okay, I talked about the 3-unit or fewer owner-occupied exemption, and this one, just because this is the largest group of exempt properties, other than single-family dwellings. So if you own a 3-unit or fewer property, if you have a 1-unit property, then that's a single-family dwelling, and you could look into submitting the exemption, after living there for 2 years. But for 3 or more, or 2 or 3. You have to live on the property, have at least a 50% interest, and once you have lived there for 120 days, then you can apply for the exemption. So the 120 days kind of just establishes that it is really your residence. It has to be your primary residence. And the unit will remain, or the units will remain exempt from rent control. We don't charge any fees. There's no control on the rent. But we will annually recertify. So there is a letter that goes out to all of these properties on the anniversary date, or the anniversary month in which it was granted the exemption, and the owner has to send back the declaration to say that they still live on the property. If they don't, then we're going to send an initial notice saying, it looks like your exemption has lapsed. And if the owner doesn't respond to that in a timely way, then we'll send a final notice, and then we will lapse the exemption. But there is a little bit of a warning period. And if the exemption lapses, then we have to look at what is the rent for the tenants who are in the units. And if a tenancy began during the period of exemption, which is often the case, then we're going to look at what was their first rent paid by the tenant after the exemption lapsed. So that's like a new fresh start. We forget, how much the tenant moved in. Maybe, you were able to increase the rent, more than we would normally allow. But it's whatever rent is in place when the exemption lapses, and that starts the new base rent for that tenant. We'll talk more about base rents. If the tenancy began before the exemption, then we would just treat it as if that exemption never happened. And we would just look back to the date that the tenant moved in, what rent they were paying, and then we would apply annual general adjustment increases up to the current date to determine what the current rent is for it. It's important to know that these exemptions are granted to particular individuals. So one, a property that's held by an LLC cannot qualify for an owner-occupied exemption because LLCs are corporations and they can't live somewhere. They don't have a primary residence. There are certain types of trusts that do qualify. So if it's a revocable trust where the trustee and the trustor are the same person, basically for family planning, then those units would qualify for the exemption. But if there's a change, so let's say mom and dad owned the unit and then they passed away and their son or daughter occupies the unit, that exemption lapses, and the new owner, because there would be a change in title, has to apply for the exemption again. All right, I think this is you, right? Are we on, right? Not me? Okay, I'm going to keep going. Sorry. Seems like I've been talking for a while. All right, so going back to the registration requirements, they're really, I mean, for owners, there aren't, a lot of requirements under the rent control law. One, you have to register your ownership so we know who owns the property. You have to keep us up to date with your address. And then you have to register all the new tenancies that you have. Yeah, yeah. For the most part, if you do those things, then there's a registration fee that has to be paid to rent control. Then you're typically good to go, and as long as you follow, our rules about what rent can be charged, and you maintain your properties. If you do those things, you're probably not going to hear from rent control at all. But as I was saying with the exemption, you have to let us know. You have to properly register your ownership, and that includes if you put the property, you had it as an individual and you put it into a trust, you need to let us know that the trust now holds title and who the trustees are. We always need the name of the individual who is responsible for the property. So if it's an LLC, who is the managing member of the LLC? If it's multiple owners, we need each owner's information and their physical mailing address, not in care of a P.O. box, because we have to be able to serve notices legally, and so we do require that you provide that information to us. There are, I didn't check, but I don't know how many of you are property owners or how many property managers, but for property managers who want to file documents with us, they need to be authorized by the owner of the property. We can't accept a form from just anybody. So we have an agent authorization form that must be signed by the owner, and then once that's on file, we will accept documents filed by the agent. And if you want, we can communicate with the agent instead of you, but we still need to have your actual address on file. So as I said, you also have to register new tenancies and amenities, and we'll talk about this, but there are some added amenities. So this is really only for tenancies that began after January 1st of 1999, and Mike is going to tell you more about why that date is significant. But for tenancies after 1/1/99, if you add a parking space, storage, or the right to have a pet, then you have to register that amount with us and when that amenity began. And then it becomes a base amenity to the unit. So it gets combined with the rent, and you're required to maintain that as a service throughout the tenancy, and the tenant is responsible for paying for that amenity through their tenancy. They can't just say, well, I don't want parking anymore. We can work out a mediated settlement usually in that case, but once an amenity is added, it is part of the tenancy. And really, it's only these three things for which you can add to the rent once the tenancy has begun. We don't allow a separate agreement or added amenities for, say, now I'm going to put in a dishwasher or a washer and dryer, or I'm going to put in hardwood floors when you used to have carpeting. You can't add little things to the rent. It's very limited, and each thing has to be registered with us. For tenancies that began before 1/1/99, Mike will talk about what their amenities are, but it is possible for those longer term tenants to add things other than parking, storage, or the right to have a pet. And we do require that registration be completed within 30 days, so that way we can keep up to date. If you fail to register, so this includes failing to register ownership, failing to register the tenancies or additional amenities, then you lose the right to increase the rent. So we'll talk about how the rents increase every September, but if you're not in compliance with the law, you're not allowed to increase the rent. If that happens, let's say you're not in compliance, but you raise the rent anyway, and the tenant pays that higher amount, the tenant can file a claim with us and get all that money back. So registration, and we're going to show you how to do it. It's very simple to do to keep in compliance. You know, ultimately you can do it on your cell phone while you're renting a unit, so there's really no reason to not register. If there's a non-registration, a hearing officer at rent control can actually say that the tenant can withhold rent until you register the tenancy. Once you register, the tenant knows the rent, but it's a way of kind of forcing compliance with our law. Okay, I did mention this briefly, and we're not really going to talk about municipal code too much, but it's important for property owners to know that when you do rent a unit, you have to rent it for a minimum of 1 year, and it is the requirement that the tenant, intend to live on the property for 1 year, and this is a way to avoid the problem with short-term rentals. We have owners who are renting units by the week or by the month, and that cuts into the city's housing supply. And so that's why the city council put this ordinance in place. So tenants have to intend to occupy the unit as their primary residence. It has to be at least for 1 year, leased unfurnished. And that's, again, a way to get away from like corporate rentals, where you're renting for a month or so. And then you have to lease to a natural person. So you can't lease the unit to XYZ Corporation or some other name. There actually is an XYZ Corporation in Santa Monica, so I should say something else. ABC Corporation. And then they, want to let their employees use the unit or something like that. So no, you have to be renting these units for people to live in as their primary residence. And there is a requirement that you collect some documentation from the tenant to show that this is their primary residence. You have several weeks, I think, to get that. Again, I would consult the city attorney's office if you have any question about this. But just make sure that when you rent the unit, you rent it for at least a year. I mentioned this earlier. For kind of added amenities, or what we call separate agreements for the pre-99 tenants, you can negotiate that separate from the rent. You do not register those amounts with us. Those are just separate. So if you had a pre-99 tenant who had, like I said, carpeting, and now you want to put in hardwood flooring, and they agree to pay you a certain amount per month for that new amenity, then that's lawful. That's fine. We don't control the rent on that. A big difference is that the tenant doesn't have to continue to pay for that. So that's kind of problematic, I guess, if you make that deal with, to put in something and then the tenant doesn't want to pay for it. You probably have a legal remedy for that. But like parking, let's say you added parking to a pre-99 tenant who didn't have parking before, the tenant could give up that parking and say, I just don't want it anymore, and you would just stop charging them for it. Or for a pet, and they don't have the pet anymore, you just stop charging them for it. The last point is that if they do breach that agreement for extra parking or something, that is not a reason to evict. You can't evict the tenant for that. But we'll talk more about the actual eviction protections in a second. This I've already really covered. one thing I didn't mention is the amount, if you're going to make an agreement with a post-99 tenant for parking, storage, or pet, has to be negotiated in an arm's length transaction. So it's what you and the tenant both agree to. So you have to have an agreement about it. You can't impose, say, no, parking space is $1,000. That if you made that agreement, the tenant could come to us and say, that is not what's available out on the market. That's excess. That's an excess rent charge. But generally, if you're going to offer something like this, just agree with the tenant what you're going to pay. When you register that amount, we send a copy back to the tenant with a letter and saying, hey, this is what the owner said that you were going to pay for this additional amenity, for the right to have, your dog. And if it's different from what they understand the agreement to be, then they'll contact us and we'll try to resolve that. So I'll move on from there. Are there any questions so far about the registration requirements? Added amenities. Oh, we've got a couple. All right, go ahead.
I have a question about additional storage. So if you have a room that you would like to rent out that's separate from all the apartments, a storage room, and one of the tenants would like to rent it, can you do a separate lease on that, or does it become part of their amenities?
So it depends if that tenant moved in before 1999 or after.
No, it's all after.
All after. Okay, so then that storage is one of the categories for which you could have a separate agreement. And yes, you could negotiate with the tenant for what they want to pay for that storage. And then you you register that storage amenity with us. And then we'll add it to the maximum allowable rent. And the tenant will have to continue to pay for that for their tenancy.
So then the next tenant has to, so in a way it's better to rent to someone off the property, right?
Well, no, because amenities are specific to a tenancy, except for the pre-99 tenants, but they're still all in place. So if you got a new tenant, you don't have to offer the same amenities that you offered the earlier one. So let's say you have a unit and it came with parking, and that tenant leaves, you don't have to rent the parking to the next tenant. Because all their amenities get reset. And Mike is going to talk more about how the rent and the amenities are tied together. But you can, between tenancies, you can take away amenities. You don't have to maintain the same amenity. Is that clear? You see?
Not totally.
So if you have you rent this additional storage space for $200 a month.
Yeah, okay.
And you register with that. With us, the rent is $2,000. Now we say the rent is $2,200. And then when that tenant leaves, you're free to reset the rent. Maybe you now want $2,500 for the unit, and you don't want to rent the storage to that tenant. Maybe another tenant said, hey, when that comes available, I would like to get that, and I'll pay you $300. So between tenancies, you can reset amenities. Okay? Yes, ma'am.
Can we use the microphone just?
Oh, for City TV, it'll pick it up when somebody watches the presentation. They'll be able to hear the question.
I have a question, okay, on application, they filled out, tenant filled out no animals or anything. And now they end up with 5 animals.
Okay.
And they are in an apartment within 10 years, and they haven't let the owner know at all.
Okay.
So what happens, what
Sure.
do you do in that situation?
Sure. So just to be clear, the question is, if a tenant signs a rental agreement, does not include any pets, and then subsequently it's discovered that the tenant has pets. Well, you have 2 options. One, you can enforce the terms of your rental agreement. So the tenant signed an agreement, which is binding, that says that they will not have a pet. And if they violate that, then you would go through the eviction procedures we'll talk about, but you could notify the tenant that they're in violation of your rental agreement, and if they don't come into compliance, that you're going to seek an eviction. So that's one option. The second option, if you now just want to say, okay, well, I'm sorry, I'm either going to evict you or I'm going to charge you additional rent for these pets that you now have. And you could negotiate with the tenant, and you're in a strong negotiating position, I would say, because you have the right to evict if they violate the rental agreement. And you just decide how much more you think they should pay, and hopefully they will agree to that amount. And then they're allowed to keep the animals, through their tenancy.
How much rent control allows for these pets? What is the,
Yeah, so there isn't any specific dollar amount that's set in the rent control law. The only requirement under the rent control law is that the amount be what is in the unregulated market. So, what would a sort of a normal person pay for a pet? Maybe that's $50 to $100, something like that. But is it, $1,000 to $2,000? Probably not. So we don't have any requirement about the specific dollar amount. It's just supposed to be, an arm's length transaction with the tenant at the amount that would be standard in an unregulated world. So, yeah, and that you register that amount with us once you make the agreement with the tenant. Yes.
I just wanted to go back to the storage question again. So let's say the tenant comes in and the owner or the landlord says, well, this apartment comes with storage, X amount, and it comes with parking, X amount. So they don't really know if it doesn't or it does, but let's say they say, well, I don't drive and I don't think I need the storage. So, I mean, then you just take it off right away. Is that it?
Well, if you're talking about a new tenancy,
Yeah, new
right?
tenancy.
So a new tenancy, you can decide what comes with the rent, or not.
But what if they don't want it?
If they don't want it, it's up to you whether or not you want to rent the unit to them. I mean, one, if you always want your tenants to rent the parking because you make more money with
Right.
that, then you can make the, renting a parking space part of the rental. That's
And the storage as well.
and the same with the storage. But if you want to accommodate a tenant who says, I don't drive anymore, and you decide to keep the parking space, it's not part of their rental, and then maybe you could rent it to a different tenant, something like that. Okay, I'm sorry, the gentleman.
She brought up a situation where there's 5 animals. Is there any limit to number of emotional service dogs or pets that you can have in a unit?
So that is one of the questions we can't answer because that is actually a federal law question.
Okay.
What is,
Fair enough.
under the Americans with Disabilities Act or whatever, how many pets can somebody have? You could, there's on our website on the more information page, we have a link to, it's a community resource directory, and there's a link there to the Disability Rights Legal Center. You might pose your question to them, or possibly to the city attorney's office. They might be able to answer that. All right, one more question and then we'll...
Can you explain in this context, what does arm's length mean?
Arm's length is just a general term. I mean, it just means that, it's a fair distance between the two parties, that one is not dominating the other party, and that it's something that is just negotiated. It's just negotiated between the two of you. That's really what it means. Okay.
All right, so I'm going to talk about maximum lawful rent here. Sorry, I'm not used to using the microphone. So the maximum lawful rent for existing tenancies is determined by adding together 3 components: the maximum allowable rent, the registration pass-through, and then in cases where it is permissible, the allowable surcharges from the property tax bill. Those 3 things combine to create what we call the maximum lawful rent. So the maximum allowable rent, the first piece, that is the base rent plus any allowable increases that have happened. So that could be annual general adjustments, that could be if you've registered additional amenities, those things all come together for what we call the MAR, the maximum allowable rent. The the base rent, the way it's determined, is different depending on if a tenant moved in before January 1st of 1999 or after January 1st of 1999. So for those tenants that moved in before January 1st of 1999, the base rent is, in most cases, what was in effect on April 10th of 1978, 1 year prior to when the rent control law went into effect, plus any general adjustments that have happened since that date. For post January 1st, 1999 tenancies, the base rent is whatever the initial rent charged, whatever rent was charged during the initial lease term for that tenant. And then coming up to present with whatever general adjustments have been added to that going forward. So that's an important date, that distinction. That was when Costa-Hawkins finished phasing in fully. So what determines the amount of the annual general adjustment? The GA is based on 75% of the annual change in the Regional Consumer Pricing Index, CPI, for the Los Angeles area for the 12 months ending in March. So annually, we get a report from the Bureau of Labor Statistics, thank you, that puts out what the change in the consumer pricing index was for that 12-month period. 75% of that amount is what the general adjustment could be. And then because of Measure RC that passed a couple of years ago, that number cannot exceed 3%. So the board also retains authority to apply a maximum dollar amount based on a formula that exists in the charter. So last year, for example, the 2023 general adjustment, it was 2.8%, but it was capped at $67. If a unit qualifies and with proper written notice, the GA can be implemented as early as September 1st of each year. Typically, the state requires 30 days notice if it is less than 10%. So as long as the tenant received their notice by August 1st, that could go into effect as early as September 1st, but it can go into effect at any point after that, even several years down the line. If an owner did not implement a previous general adjustment, it does not expire, and it can be prospectively implemented as long as proper notice is given. So if you miss giving the notice, you can't go back and say, I need to collect this money that I didn't collect because I was entitled to it. Instead, you have to give notice and you can collect that increase going forward. So we talked a little bit about this already, but when can the general adjustment be taken? It goes into effect on September 1st of each year. So it can only go into effect September 1st or after. And that is only if all registration fees have been paid and penalties, if there are any tenancies at the property have been properly registered. A tenant that moved in after July 31st of 2017 has received the rent control information sheet, and we do have some rent control information sheets in the back. If anybody needs any copies of those, they're also available on our website. There need to be no uncorrected citations or notices of violation of health or safety or housing laws for the unit or the property. And then the property has to be in substantial compliance with the rent control law. State law requires that proper notice be given, and a tenancy has to have been in effect for at least 12 months before it qualifies for a general adjustment. So how can I learn the MAR for a unit? Each June, we send the property owners a MAR report to assist in preparing the annual rent increase notices. You'll need to check on that form that the tenancy date that's shown on there is consistent with the tenants that are actually in the building. If you see an older date there, that means that we haven't received a tenancy registration form. If you see pending there, that means we've received a form that it has not fully been processed yet. There may be an issue with it. It may just be in the queue to be processed, but that's why you would see pending in that report. Any other time of year, you can use the Look Up a Rent tool on our website. It is on, if you go to our website, santamonica.gov/rent control, you click on more rent control topics. You scroll down on that second page, the first tile you'll see is Look Up a Rent. It's circled here in red. That'll take you to a page, the maximum allowable rent database. And on that page, it can be a little bit temperamental if you don't follow the pattern exactly right with the number and the street name and the proper suffix of the street. So for example, if it was a property on 14th Street, if you typed in the word 14 instead of 14, it would not return a result. So just a heads up on that. All right, there is a registration fee for rent control. Dan talked about that a little bit. The annual registration fee for controlled units is charged to property owners by the Rent Control Board. It's charged for all units unless a fee waiver or an exemption has been granted. The fee waiver is currently $228 per unit per year. And as long as the owner pays that annual fee on time, which is by August 1st, then they're able to pass through 50% of that registration fee to any tenants that they have on a monthly basis. So that would be a $9.50 charge that you're able to add. That's that second part of the maximum lawful rent. There are several registration fee waivers that are available, mostly to low income, very low income seniors. Seniors in Santa Monica is considered 62 or older for these purposes. And then for low income or very low income disabled tenants, permanently disabled tenants, that fee waiver would cover the total cost of the unit, so the whole $228, not just the 50% that is the tenant's share. Also, if you have any Section 8 tenants, those qualify for a Section 8 fee waiver. That also covers the whole fee. And then owners who hold at least 25% interest in a property as a natural person or certain kinds of trusts, they can get a fee waiver for their unit, an owner-occupied unit. Generally, this is one that doesn't qualify for an exemption, but they still want a fee waiver for their unit because they're not renting that unit out. If a fee waiver is approved, the registration fees are not charged for that unit, and there can be no registration fee pass-through because it wasn't charged. So there's no right to charge the tenant or recoup anything if that was zero. These income amounts for these different fee waivers, they do update every year in July. So, if you know anybody who's interested in these, have them come by our office or call us, and we can verify what those amounts are at the time that they're interested in filing. Now, in some cases, there still are allowable surcharges from the property tax bill that can also be added to the rent. That's the third piece of our maximum lawful rent. Allowable surcharges are based on the owner's property tax bill. And these taxes are voted indebtedness. These are things that were voted on by the residents of Santa Monica for the public benefit in Santa Monica. So at the time that passed, it was it was considered fair that landlords would be able to recoup some of those costs, since the tenants are the ones who are voting for it and benefiting from it. There are so the surcharges for the existing tenancies are capped at either 4% of the rent, or of the MAR rather, or $35, whichever is less. There aren't a lot of units left where 4% is less than $35, but there are a few of them still out there. Typically, those pre-99 tenants in smaller apartments, we see a handful of them where 4% is less than $35. I can't quite do that math in my head, and I should have done it because I thought about it yesterday, and I didn't know the math yesterday either. But I think it's somewhere in that like $600 something range would be 4% being less than $35. So surcharges cannot be passed through for new tenancies that began March 1st of 2018 or after, or if the building has been sold or had its value reassessed after that date. So because there's been a change to the taxes, or because there's a new tenant after that date, you're no longer allowed to pass through the surcharges from the property tax bill. In that case, we would recommend that you use our simplified version of the notice of change in terms of tenancy, because it does not include the Section C surcharges from the property tax bill that you'll see on the notice of rent increase. Here's a zoomed in version. You can see the screenshot of an older annual property tax bill, as well as the the 5 items that are able to be passed through for qualifying tenants. You'll have to do the math on this and get the total number off of the property tax bill, divide that by the number of units on the property. That'll give you the annual per unit amount. And then divide that by 12, that gives you the monthly per unit amount for that line item. You add all of those things up. You also do the math to show that 4% would be more. And then your item 5 here, there's a little black circle with a number 5 in it. I'm not sure if that comes through for everybody. But in that box, you're going to put either the number from 5F, the number from 5G, or $35, whichever one of those numbers is lower. And then you'll add up the total for D there is going to be your line 3, your line 4, and your line 5, which I believe we're going to talk about on the next slide. Yeah. So here you'll see a notice of change in terms of tenancy. This is our long form. And you'll see on the left-hand side here, numbers 1, 2, and 3 on the top. This form is what you get. This is the MAR report that we send out. You'll see there's a site address here. It's got what the MAR for the unit is, the current MAR as of the date of the mailing. It'll have a market rate established date. And for tenants that moved in before January 1st of 1999, there was no market rate established because that rent is still based on the 1978 rent. So there's no date there. For tenants that moved in after January 1st of 1999, there is a date there. And that's the date that I want you all to make sure that you're checking to make sure that it's consistent with the tenants that are in there. Or if you have a tenant that you know moved in after 99 and you don't see a date there, probably the rent will look way off too. But you'll notice that as a reason that maybe you need to register that tenancy or to call our office to check on it. So we've numbered these columns 1, 2, and 3. The current MAR is column 1. The general adjustment amount, it's either going to show as a percentage or a dollar amount, is number 2. And then you'll see the new MAR, which is the sum of 1 and 2. Oh, excuse me, I'm sorry. In that third column. And those correspond with some numbers that we have on the side of our form, number 1, number 2, number 3, and you're able to just move those numbers from one form to the other. And we've done that first part of the math for you. You'll see on the left side it's labeled as B. On the right side it's number 4. That is the $9.50, the rent control fee. Right? So if you're adding that fee, if you're eligible to add that fee, that goes there. Again, I just explained the property tax bill and where those line items go, but that's illustrated here as well. And then the most important line here, I think it's the most important line here, may disagree, but that's going to be your new total rent. And that's going to be line 3, line 4, and line 5 all added together. So that's your new MAR, your rent control fee, and surcharges from the property tax bill if applicable. And then there's a space at the bottom to sign, put your address and date. All right. There is an exemption available for the SMMUSD Measure R, the school district parcel tax. Exemptions from this tax are available to property owners who meet certain qualifications. They have to be 65 or older by June 30th of the year in which they apply. They have to occupy the property as their primary residence, and they have to apply with the school district to get that waiver. When that waiver is granted, no school district parcel tax is charged to the property at all, so that line cannot be included in your surcharges from the property tax bill. There's also an exemption for the Clean Beaches and Oceans parcel tax. This is for low-income, very low-income owners, and then tenants can also apply for this as well. And then again, if the owner gets the exemption for the whole property, that line item can't be included for any of the tenants because the owner's not being charged, so there's no right to recoup anything because it's not being charged.
Just interject there that Curtis Castle recently left the city, so that is not the correct person to contact. You
Sorry about
contact it's the Office of Sustainability and the Environment, and then they can help you with that application if you qualify.
I did not know that.
Yeah, I tried to find who it was, and I didn't get answers.
No worries. Do we have any questions about this section? Let me get
Dan, do you mind doing the microphone?
Make sure it's turned on. It might have turned itself off.
I think it's on.
Yeah, good.
Thank you. As you were speaking of one of the items there, the city passed items where the tenants voted on them. And it made so much sense when you said the tenants voted on them, so it made sense to pass it through the tenants at the time. How did that change?
So after that had been going on for a while, and there was turnover, the tenants that moved in after that date, presumably the costs of running your business for renting that unit, it's all folded in there. So you already know what your costs are and your taxes are for your unit as of going forward, versus the tenants that had been in there before those laws were passed, where there was no real good way for a landlord to be able to recoup those costs. So there was no good way to increase that rent based on those taxes. This allowed landlords to recoup those costs that were being added on to tenants where there was no other way to adjust their rent prior.
I'm actually following you.
All right.
I'm just curious, if you don't take an increase or give your tenants an increase 1 year, and then the next year, let's say it's $35 for 1 year, you don't take it, next year it's $35, can you increase by $70 or only the $35 for the current year?
You would be eligible to increase as much as the new maximum allowable rent is,
Got it.
including any general adjustments that have passed over that time. So it could be 2 years of general adjustments, it could be 5 years of general adjustments. If it started to be a high number of general adjustments and you start creeping towards 10%, I would be cautious that the noticing requirements may change from the state level, but it would take quite a few general adjustments to get to a 10% change in somebody's rent. Any other questions on this section? All right, moving along. All right, petitions and complaints, everybody's favorite. All right, so complaints for excess rent. Complaints for excess rent may be filed by tenants who believe they are being or have been charged amounts that exceed what is allowed by the rent control law. There is a new piece of this regulation that requires tenants to first notify landlords and give them 30 days to correct the situation. So 30 days before the tenant is allowed to file, they need to provide written notice to the landlord, making a claim of how much excess rent they believe they've paid and why. And then in most cases, we found that landlords and tenants have been able to identify what the problem was and work it out. But if that doesn't happen, then after 30 days have passed, the tenant is able to file their complaint for excess rent with our office. If that goes to a hearing and a hearing decision determines that excess rent has been collected, the tenant will then be authorized to withhold rent until the excess rent has been recovered. Interest and penalties can also be included in the amount of an award. So there are some common examples of excess rent. There's nothing in the rent control regulations that would allow a landlord to increase the rent based on adding an additional occupant. So if a landlord does charge for the additional occupant, I know, for example, like in Los Angeles, you're allowed a 10% increase for an additional occupant. Sometimes we see property managers who are working in multiple jurisdictions, they'll just apply the wrong city's rule, thinking that, without checking with us first. That would be a pretty common excess rent complaint. Unregistered additional amenities. So if you entered into an agreement for an additional parking spot and you never filed that form to register the parking spot with us as an additional amenity, and you've been charging for that, that could be excess rent. Utility charges, particularly if they're fluctuating or trying to implement like a ratio utility billing system, something like that. Those are things that are common. Improper noticing of rent increases, so not giving that full 30 days notice for a rent increase. And then an improper pass-through of surcharges. So accidentally including the $35 from the property taxes for a tenant that moved in after March 1st of 2018, that would be another example. So speaking of utility costs, can tenants be charged separately for utility costs? When there is a separately metered, a unit is separately metered and the tenant pays the utility company directly, a tenant can be required to pay those utility costs. There's no issue there. If a property is master metered and the lease requires a tenant to pay a share of the monthly utility bill, the owner must specify what that monthly amount will be, that exact dollar amount, at the start of the tenancy. So you're not able to have that number fluctuate or change in the summer if air conditioning use goes up, for example, or water use goes up. It has to be a set amount, and that has to be determined at the very start and agreed to when the lease is signed. So ratio utility billing systems, known as RUBS, those are not permissible in Santa Monica in rent control. So we also have petitions for rent decrease. Tenants may file a petition for a rent decrease when necessary repairs are neglected or for the reduction or removal of amenities or housing services. If a rent decrease is granted, it will remain in effect until repairs are made or the amenities or services are restored. Owners who wish to remove a base amenity or housing service may also file a decrease petition. So it doesn't have to be the tenant that files, a landlord could file as well. And that would be an example, like if you were removing parking spaces to build ADUs or something like that, and the tenant had a parking space, removing it in that way would remove it from the MOR. And what maintenance is required? So in addition to state law and other local laws, rent control regulations provide remedies for failure to make necessary repairs inside units and in common areas. These might include issues, and this is not meant to be an exhaustive list, but water supply, water leakage, worn paint, heat, elevators, porches, counters, smoke alarms, screens, insects, appliances, dangerous walkways, broken windows, doors, electrical plumbing problems, anything like that, any of that basic maintenance. Base amenities and housing services are more things like parking, a refrigerator, smoke alarms, storage, other appliances. The right to have roommates, that's a base housing service. Carpet, window coverings, the right to have overnight guests, stoves, screens, the right to have a pet, including services to common areas such as gardening, laundry, on-site management, a rec room, pool, gym, things like that. Now, the way base amenities are determined is different, again, based on that 1999 date, that January 1st of 1999 date. For tenants that moved in before January 1st of 1999, it's based on what came with the unit when it first came under rent control, April 10th of 1978. So if it was first rented and came under rent control after that date, then that would be the initial date for it. But going back as far as that is. And it doesn't matter how many times a unit has turned over from 1979 to 1999, those base amenities are still based on that first time that unit was rented under rent control, or when it first came under rent control, usually April 10th, 1978. Now for post January 1st, 1999 tenancies, it's a little bit more straightforward. The way that the base amenities are determined is just what the tenant had when they moved in. So everything that they agreed to in their lease when they moved in, those are or that could reasonably expect to have had, those are their base amenities. And then those reset, like we talked about, every time that tenancy turns over. So every time there's a new tenancy there, and the example that Dan gave was you had a tenant in there that had parking, the amount that was agreed to was a certain amount, that tenant moves out, a new tenant moves in and doesn't want parking. Now you set a new base rent that doesn't include the parking, and they don't have access to that parking, or vice versa. They could have not had parking, and now you want to give them parking because you think that makes the unit more desirable. So it's a fresh start for that unit. All right, the other kind of decrease petition that we have is for construction-related issues. These may be granted when a unit is uninhabitable due to the construction, or when construction substantially reduces a housing service, or when construction interferes with a tenant's ability to occupy a unit as a residence. No decrease is authorized for unavoidable construction impacts caused by necessary repairs or maintenance unless the construction is carried out in an unreasonable manner or the construction takes an unreasonably long time to complete. Regulation 4400 is it's chapter 4 of our rent control regulations. That sets the decrease ranges for many possible issues. Again, it's not an exhaustive list, but it's pretty comprehensive. And then there are mediation services that are available. We do try to mediate this first. It's important to know things that are mandated, like seismic retrofit. Those are typically things that, as long as they're done in a reasonable manner and they take a reasonable amount of time, we do not grant a rent decrease for those. All right. Are there other times when the MAR can be adjusted? There's something called a tenant not in occupancy petition that an owner may file, and that's for a one-time increase if the owner believes that the tenant does not use their unit as their primary residence. If this is proven in a hearing, then the Rent Control Board will grant a one-time market rate increase. So, you know, sometimes this comes up, like if a tenant is subletting because there's no provision in their lease that says they can't sublet, they've moved away and they continue to sublet that unit. A tenant not in occupancy petition may be your best bet to fix that behavior. There are also individual rent increase petitions. An owner may file a petition for rent increases based on unusually high expenses, such as capital improvements. These petitions must include all of the units on the property. So it's really about, averaged across the whole building, are you able to continue to make a fair return? And that fair return is based on what was the return on the building when it first came under rent control in April 10th, 1979, because at that time, that was an unregulated market. So presumably the return that was taken in at that time was fair. With adjustments for inflation, yes, sorry. That's an important piece, because all right, so we did speak a little bit about mediation. We do try to mediate these petitions first. In 2023, there were 87 decrease petitions filed, 22 excess rent petitions filed, and 24 construction-related petitions. 33% of decreased petitions were mediated and fully or partially resolved just in the mediation. 77% of the excess rent complaints were resolved by mediation, and 44% of construction petitions. So it's good to see the effectiveness of that. All right, do we have any questions on this section?
Yeah. If you can touch on right to have roommates, is that?
Yeah, so base housing service includes how many people live in the unit when you start the lease for a post-99 tenant, right? So if you have a 3-bedroom, just as an easy example, if you have a 3-bedroom unit, there's 3 roommates that move in, that's your base housing service, is 3 people. If one of those people moves out, they have the right to replace that roommate, and that cannot be unreasonably denied by the landlord. Now, you could do all of the reasonable things that you would do to vet a normal new tenancy. That's okay. But you can't just simply unilaterally say, no, I only want 2 people there now, because their base housing service was 3. And if you were to deny that and it was to go to hearing, the rent could be reduced by 1/3 because 1/3 of the housing service is not there anymore. Did that?
I just wanted to be sure you didn't have like 2 people to begin with, and then they said, hey, we'd like to have a 3rd, just here we go.
Yeah, so the base housing service is what's important there. The exception would be marriage, registered domestic partner, or the birth or adoption of a child, or becoming primary custodian of a child if they didn't have primary custody before.
Yeah, so those are protected by the municipal code, not from rent control, but yeah, you could have those additional occupants.
In the example you gave with a 3-bedroom and they, one roommate moves out, then you can have the new roommate sign a lease.
Yeah,
Yeah.
yeah. It has to be materially the same.
And the tenant who does want to replace a roommate does have to give you the information about that tenant in writing before they bring the person in.
So do all tenants, including roommates, have to be on the lease?
No, They don't all have to be on a lease, and there's actually no requirement under state law that there's even a written lease. So, you know, that's hard to enforce if there's no written lease. It's hard. But there are several options available to you under state law and how you recognize who has the right to be in the apartment.
So the tenant does have the right to replace a roommate, but you don't necessarily have to put that new person on a rental agreement. And some landlords are wary of doing that only because they're afraid of establishing a new tenancy with that person. And if the other two people leave, there may be a question under state law whether or not the owner has the right to reset the rent because they have a qualifying vacancy under Costa-Hawkins. So there's sometimes case specific. One other thing I'll mention is if you have a tenant and they have a roommate and the roommate's not one of the original tenants, but they're allowed, and that original tenant leaves or gives notice that they're terminating their tenancy, and you collect rent from the remaining person, then you've established a tenancy with that person because you've been given written notice that the other person is leaving and you accept rent. And if you accept the rent, the same rent that the old tenant was paying, then that's the new base rent and you're stuck with it. Okay.
All right.
Anything else?
All right, moving along. All right, so evictions, that other, you wanna go?
I think that's neat.
All right, you wanna go?
Just to switch it up. Okay, so as I mentioned, one of the legs of rent control is the protection against eviction. So there are 10 reasons for evicting a tenant. 7 of those are things that the tenant does wrong, and 3 are no-fault reasons. But so there's a section in the charter. It's section 1806 that lists the reason for which tenants can be evicted. But in all cases, owners must serve an eviction notice on the tenant, and that starts the legal process. When you do that, there is a requirement under the rent control law and separately under the municipal code that you send a copy of that eviction notice to rent control and to the city attorney's office. You can send it by email, any way you can get it, but you're required to send it within 3 days. So if you fail to do that, a tenant can get a statement from our agency saying this notice is missing, we don't have it, and they possibly could use that as a defense in court. So it's really important to send a copy of the eviction notice to us. We don't require it if it's for non-payment of rent, but the city attorney's office does. So probably the safest thing in your mind is just if you ever issue an eviction notice, send a copy to rent control and to the city attorney's office. There are, one of the reasons that it's not the fault of the tenant is an eviction for owner occupancies, that an owner can move onto the property. I'm going to talk about the requirements for that. And then for a few reasons for eviction, there is also a requirement that before you issue the eviction notice, you give the tenant a written warning. And that is for a lease violation, refusing access to the landlord for when they do have access to the unit, nuisance, if the tenant is conducting a nuisance on the property, and so refusing access. Anything that could be reasonably corrected. How about that? So if there are a few reasons, you have to warn the tenant first. You don't have to send a copy of that to rent control. But if it is one of those reasons for which a tenant should have gotten a warning and we get the eviction notice, we're going to send a letter to the tenant saying, hey, you should have gotten an eviction notice. We're not involved in tenant defense. If any tenant contacts us regarding eviction, we just say, get an attorney. We can't provide any legal services, so we don't. As I said, there are really two different categories for evictions. One are tenant fault, things like non-payment of rent, violating an important condition of the rental agreement, causing substantial damage or substantial nuisance, or refusing lawful access to the rental unit. Then there are the no-fault reasons, which you could still seek an eviction, owner occupancy, which I just mentioned. Then there's withdrawal of the property under the withdrawal from the rental housing business under the state Ellis Act, and I'll talk about that. And then finally, a removal permit. These are very limited reasons why you would be able to evict a tenant, and I'll talk about that in just a second. And for these no-fault reasons, there are also requirements under the municipal code that tenant be paid permanent relocation. So there's a schedule set by the city depending on the size of the unit, and also if the unit is possibly occupied by a tenant who's 62 or over or disabled, there's a higher amount that has to be paid. Or a minor child. And these amounts are increased every July 1st, so you have to pay the amount that's in effect when the tenant actually vacates. We'll talk about it in a second. But one important thing is that the end of the lease is not a reason for eviction. So if you sign a 1-year agreement with the tenant, it doesn't mean that at the end of that 1 year that you can tell the tenant they need to move. They continue their tenancy. Just by default, it goes month to month. You could sign a lease extension if you wanted to. You could demand that the tenant sign an extension of materially the same terms as their original agreement. So if it was a 1-year agreement, you could require them to sign a 1-year extension. You can't change the terms. But if they refuse, you could seek an eviction for that. But just generally the end of a lease is not a reason to evict a tenant, so they stay in place. There are limitations on eviction.
We have a question still at the end of the section.
If you have a question now, that's all right.
Okay. Thank you. Thank you. You mentioned that tenant fault would be refusing entry, and you also mentioned that it also could be refusing access could be a written warning. So which one is it, or is? Okay, so if a tenant is denying the owner their lawful right to enter, and of course that would require proper notice under California law saying I'm coming in, for this reason, and the tenant does not allow the owner in, then the first step, because that reason does require a warning under our law. So you have to give the tenant a warning with a reasonable amount of time for the tenant to comply. And that's, not specified in law, but it's something that you would want to be comfortable with if you ended up in court trying to evict this tenant and you said, well, it was unreasonable for me to be able to give you access, within 24 hours. I don't know for what reason, but you'd give a warning, and then if there was non-compliance, then you would issue the eviction notice and send a copy to rent control and to the city attorney's office. Okay. So to evict for owner occupancy, the owner has to be a natural person. So I think an LLC or something like that cannot evict a tenant. And this doesn't apply just to properties of 3 units or fewer, which we have an exemption for. So just don't confuse those things. You could have an 8-unit property and the owner wants to live in one of the units. So that's fine. The law does allow an owner to evict for owner occupancy, and it can either be for the owner himself or herself, or for a close family relative. So father, mother, brother, sister, son, daughter, I think mother-in-law, father-in-law is included. But not grandparents, not grandchildren. It's a limited list.
But if you have any question about that, you can contact us. We'll tell you the exact, the enumerated relatives. The owner does have to move in good faith. You can't just evict and then say, I'm coming in for owner occupancy, but not move in. You have to intend to move in within 60 days of the date that the unit is vacated, and then occupy the unit as a primary residence for at least 2 years. If a tenant doesn't, if you don't do this, you don't move in 6 days, the tenant might sue you for an unlawful eviction. So you do want to comply with that. You cannot evict for owner occupancy if the owner or an enumerated relative already lives on the property. You only get to evict for one unit for that purpose. And then if you evict for owner occupancy and then subsequently rent the unit, that is not a qualifying vacancy under the Costa-Hawkins law that allows you to set a new base rent. The rent goes back to what that displaced tenant was paying, plus any general adjustments that occurred in the interim. So we track that in our database. If we get an eviction notice for owner occupancy, we restrict the right to set a new base rent. So if you register a new tenancy and something other than what was allowed, that tenant that you just rented to can come to us and file an excess rent complaint and have their rent reduced to what the displaced tenant paid. And this could be for 20 years. So if you're owner occupying and you're going to vacate, it'd just be good to check with us to see if there was an eviction for owner occupancy. You probably know that, but it could have been a change in property ownership and you weren't aware. But
Is there, does the landlord owner have to pay a fee to an individual if he takes over an apartment and then vacated?
so if an owner, the question is, will an owner have to pay a fee to the tenant if they evict for owner occupancy? And the answer is yes. So for all the reasons for which a tenant is not, didn't do anything wrong, so the no fault reasons, all of those, the owner is required to pay permanent relocation.
Is it the same? It's the same fee for any of those?
It's the same schedule, yes. Depends on whether you're removing the unit or you're withdrawing the unit under the Ellis Act or you're evicting for owner occupancy. It's the same fees. That's the next point. Relocation benefit must be paid. And you have to put that into an escrow account. We have forms that you can get, so I call it our eviction packet, and it has all the forms that you'll need to be able to evict a tenant for no fault reason. There are, I don't know if anybody here is involved with a TORCA unit, but there's a unique class of condominiums in the city that were converted from apartment buildings to condominiums. And this was a law that was in place from 1986 to 1996. But the tenants who were on the properties at the time that conversion was approved cannot be evicted for owner occupancy. So sometimes you'll see condominiums come onto the market and they are well below market price. And it's a possibility that the unit is occupied by one of these long-term tenants who you cannot get out. They have eviction protections. You can't evict them for owner occupancy, and they would continue to pay the rent, their standard maximum lawful rent. So if you are involved with somebody who's looking to purchase a property that's a condominium, and that's a TORCA. TORCA stood for Tenant Ownership Rights Charter Amendment, and it was a way that tenants could possibly buy the units that they were in if they agreed to this conversion. If they didn't want to buy, they could just remain as tenants and have this eviction protections. But the city's planning department does have a list of the tenants who were on the properties when these conversions happened, and so you can tell whether or not this tenant is protected or not. So more requirements for eviction for owner occupancy. you cannot evict from a unit if there's a comparable unit on the property of the same size. So if there are 5 units and there are 2 3-bedrooms and you want a 3-bedroom, if there's a vacant 3-bedroom, you have to take the vacant 3-bedroom. You can't evict the tenant who's in the other 3-bedroom. There is an exception if there's a variation in the square footage between those comparable units of 15%. And then you could take the larger unit if you wanted to, even though another one might be vacant. And so this is not under the rent control law, but the city extended eviction protections to properties that are not subject to rent control as well. And they're very similar to those protections that are for rent-controlled units. The city also put in some other substantive protections for eviction, and those are for units that are occupied by a child under the age of 18, or any educator living in the unit. So it has to be a student. A student under 18 cannot be evicted during the school year. Tenant, the same with the teacher. A child or educator is a tenant in the unit or has a custodial relationship. The tenant has lived in the unit for at least 12 months or more, so that's a requirement. And again, the date the tenant falls can't be during the school year. Because you will file the eviction notice with us and with the city attorney's office, it's likely the city attorney's office would get in touch with you if you're trying to evict somebody during the school year. Okay, are there any questions on eviction? Generally, I always say, if you're going to do it, get an attorney. That's the safest way. And for tenants, we also say, get an attorney if you need to make a defense. But we don't provide any legal services at rent control. We just refer people to the Legal Aid Foundation or some other nonprofit. Okay, no questions. So we'll go on to what was another leg of the rent control law, which is the limitations on the change of use of a controlled unit. So there's 3 ways. Two ways. Withdrawal, removal. Removal and withdrawal. So removal, I'll talk about in a second, and the Ellis Act. Removal is the unit can't be made habitable. Again, just like with evictions that aren't the fault of the tenant, if you go out of the rental housing business or remove the unit, you do have to pay the permanent relocation. So a removal permit is something that is only granted by the Rent Control Board upon an application, and there are really 2 cases in which a removal permit might be granted. The first is that the unit is uninhabitable and it cannot be made habitable in a feasible manner. The determination of uninhabitability is made by the city's code enforcement division, but what we see are things like a former laundry room or something that was converted into a unit and the tenant started renting it. And then it was discovered by somebody that this is not a lawful unit. It may have been registered with rent control. So back in '79, when owners were registering tenancies, they may have registered this laundry room as a controlled unit, and it would otherwise be protected under the rent control law. But if code enforcement comes in and says, well, no, the ceiling height is only 5 feet, or it's not even 200 square feet, or it just doesn't meet the requirements for habitability, then and there's no way that the owner could make it habitable. You can't raise the ceiling or expand the square footage or something. Then the owner would apply for a removal permit, and the tenant would get paid the permanent relocation. So it's not a good idea to rent these uninhabitable units. People have rented garages and all kinds of things to tenants. So even a garage, if it's it's not habitable, the city would require that you pay permanent relocation. But the other way that a property might be removed is if the owner wants to redevelop the property. And as a condition of redevelopment, the owner says or agrees to replace as many rent-controlled units as were there before. So it's a 4-unit property, and they want to knock it down and build another 4 units, or 5 units, or 6 if the city would allow it. 4%, at least 4 units on that new property have to be under rent control. So that's part of the removal agreement that's made with the board. And additionally, at least 15% of the units would have to be affordable to a low-income family. So there are limitations on the rent. Last point is that the removal permits do expire if you don't act on them. But we don't see a lot of removal permits these days other than by affordable housing producers. Most of the time, if somebody wants to go out of the rental housing business, they want to demolish their building. So you can't just demolish a rent-controlled building because you have to find a process to get out from rent control. If you can't do a removal permit, then the option would be the Ellis Act, and that's a state law that went into effect in 1986, and it allows an owner to go out of the rental housing business. So in good faith, the owner just says, I don't want to do this anymore, and they evict all of the tenants on the property. They are required to pay relocation to all of those tenants. And then there are restrictions on the property going forward because technically you're going out of the rental housing business. There's a requirement to start this to file a notice with rent control. That starts the whole process. You have to file with rent control to say you're going out of the rental housing business. You have to notify tenants that this is going to be happening. Relocation, again, has to be put into an escrow account prior to even serving the eviction notice on the tenants. And then, depending on who's in these units, they would either have 120 days before they had to vacate, or if they are 62 or older or disabled, they can request, basically require that they not vacate for 1 year. And that is the effective date for the Ellis, is that 1 year date. You cannot, there's some limitations on Ellising. You can't Ellis a property within 1 year of an initial lease term because you've leased the unit to that tenant and they have a right to it. Once that tenancy goes month to month, after 1 year, then you could possibly Ellis, but you can't do it if you've just rented a unit. And condominiums, because they don't meet the definition of an accommodation under the state law, can't be Ellised. So you can't take a single condominium and say, I want to go out of the rental housing business. Can't do that. The last thing we'll talk about is buyout agreements. So one other way to gain possession of a unit would be just to negotiate with the tenant to leave. So these have to be done carefully. You can't harass a tenant. There are some new laws in place for tenant protection in the city, and among those are prohibition against seeking a buyout if the tenant has already told you in writing that they're not interested. So that you can't keep pestering the tenant to try to get them to buy out. But there isn't any requirement in the city in terms of the amount, other than it cannot be less than what would be required under the permanent relocation ordinance. So I told you there's a schedule depending on the number of units and things like that. And so you have to offer the tenant at least that amount. And then tenants have the right not to accept it. They don't have to get bought out of their unit. They can refuse you. They have rights to seek an attorney. Some buyout agreements used to say that tenants cannot consult with an attorney or with rent control. They just have to make this decision on their own, which isn't fair. And then an important consideration is that even after a tenant has accepted a buyout offer, they can back out of it within 30 days. So just keep that in mind. The charts here show what the average buyout amounts were in the city last year. And, you know, probably the one that's more telling is the unit size comparison. So you see, you know, depending on the size of the unit, what kind of buyout offers there were. But on average, they were 53,711 last year. You consider the tenants who are maybe long-term tenants who aren't paying us, you know, much rent. There's more of an incentive for the owner to get them out so that they can re-rent the unit at a market rate. There are no restrictions on the subsequent re-rental of the unit after a buyout. So if a tenant voluntarily vacates, then under the state law, you're free to set a new base rent with the tenant, with the incoming tenant. So are there any questions on that? Okay.
Thanks. I do have a question, and that is, what happens to the property afterwards? I've heard that it has to remain, you can't go back into business for 5 years or something.
Yeah, that's right. So I said I thought I had slides on that. Sorry. So if you withdraw a property under the Ellis Act, there are restrictions for, well, first of all, I should say, if the property is ever re-rented again, it would fall back under rent control, even if it's 20 years later or 25 years later, and we've seen that. If the units are rented within 2 years of the withdrawal, then both the tenant and the city can sue the owner for a bad faith withdrawal. And for up to 10 years, if a tenant says that they want to return to the unit if you come back into the business, you have to offer the unit back to those tenants who say they want to come back. But after 5 years, you could rent it to them at a market rate. If you come back in within 5 years, we go back to what the displaced tenant was paying, plus any general adjustments that would have applied, and that's the new rent. Whether it's the same tenant or a new tenant. Within 5 years, the rent is restricted. Again, within 2 years, and we don't see this happening much because there's a possibility of penalties, the tenant can sue. But within 5 years, you rent it back at the same rental amount plus any general adjustments. After 5 years, you can rent it at whatever the market will bear. And for up to 10 years, you have to offer it back to the tenants who said that they wanted to return. There's also the redevelopment of a property. So if a unit or a building was Ellis'd and demolished and new units were built, if those new units are offered for rent within 5 years, then the property is subject to rent control. Because the old units are gone, the owner can set a market rate rent for those new units, but then they're controlled again. If the property is not offered for rent until 5 years and 1 day, then it's not subject to rent control. So this is a newly constructed building. There may be requirements, from the city, other departments of the city, that there be some affordable units on the property. There are other requirements, but as far as rent control goes, after 5 years, you're typically allowed to set a new market rate rent. Anybody else? Any questions? All right, with that, let me go over to, and this is the PowerPoint. I don't see my, how do you do it? Can you check that? Why is giving me this stuff? Yeah, let's see. I want to just. I don't have the. I don't know. Oh. So this is. I just want to show you our online civics portal. Oh. So, does anybody here have a CIVICS account? I'm just curious. No? Okay. Well then, yeah. Something new here. So this is a system we introduced, I guess almost 2 years ago now. And it allows property owners to file the registration forms that we were talking about earlier online. There's a lot more you can do as well in terms of you can even pay registration fees through the system, and you can get information about the property through the system as well. So the website address is rent control at santamonica.gov. So that's a key thing to remember. Once you're there, at the bottom you'll see create a profile. And this was the place to start. So you're going to click here, and it's going to take you to an online form where you just identify who you are and what properties you own or manage. And we review these forms, so it doesn't instantly create an account for you. We look at what the form, and then we decide. Okay, so we for example, if you're a property manager and you want access to certain properties that you own or manage, we have to first confirm that you actually are authorized by the owner to have an account. So it takes us a little bit of time when we get these account requests to just verify that that you have access to the properties. Let me just log in as myself. And so once you complete that form, you'll get an email from us. It actually comes from Hanson at smgov.net, but that gives you a temporary password that you can use to log in. And then you're going to see a dashboard like this. You'll see there's a submit a record form or tab, and that will list for you the types of forms that can be filed through the system. We're always working to upgrade the speed of this, but I don't know about the library here.
We're also on Wi-Fi right now, so it's a little bit slower than
usual. Or a lot slower. So, like I said, you can file an ownership registration form here. You can file a change of mailing address form. You can file a tenancy registration. You can pay fees on the system. And I don't know why it's taking so long here. Is there a Wi-Fi connection here? While that's loading, because the key thing I would like to show you is for each form that you file, you're required to identify what's called a primary site. And so if it's an ownership change or change of mailing address, then it's the property address. If it's a tenancy registration form, then it's the specific unit. And so there's an opportunity, and when this comes up, you'll see that there's a create, I think it's a choose primary site. And it takes you to a form where you can enter the property address. And it's kind of like our look up a rent form in that you have to match exactly, the records that are in our system. Oh, there we go. So less is more on this form. Let me show you here. Okay.
You're back on the dashboard.
Do I go with that or do I go submit a record? Let me try one more time on submit a record, see if it, there we go. Okay. So you'll see there are various forms here, tenancy registration, they're the added amenity form, like if you add parking, storage, or pet, authorized agents, change of mailing, that sort of thing. The most common one is tenancy registration. There are instructions here. If you read them, they are helpful. And then for every form, you're going to see this add primary site. And for a tenancy registration form, first we want to know that it's after January 1st, 1999, because otherwise we're looking at that 1978 rent, so nothing to register. So you go to add primary site, and here is where less is more. So if you just enter the number and the street and nothing else, you don't need to add the directions or the city. Everything's in Santa Monica, we know that. So then you just search, and you have to scroll down, you'll see the results. So if I wanted to register a tenancy at 1431 Centinela B, you just hit the radio button and then add site. And here it appears over here. So this is how you always pick the site to begin registering a tenancy. Then you save and continue, and you'll see that there are sort of tabs going across the top to let you know where you are in the process. And this next page is when you start entering all of the requirements. We do have a kind of a check field here to make sure that you're registering the right unit. Then we have like when did the tenant move in, how much is their initial rent, are you charging them a registration fee for these tenancies before March 1st, 2018, are you charging any surcharges and the total rent, parking information, that sort of thing when the other tenant vacated. And then in the signature area, so this is digitally signed, one, you have to indicate that you did give the tenant that rent control information sheet, which is in the back. For all new tenancies, they have to get that sheet, and you had better check this box or we're not going to allow general adjustments. So that's an important thing to do. When you're done, you save and continue. I will go back rather than submitting anything. But once you do that, you'll see.
Can I just add?
Yeah.
Quick? There's also an idiosyncrasy on that page where, in addition to the date, the system requires a time, and that is a required field. And sometimes people miss that, and they keep getting bumped back to this page, and they can't figure out quite why they can't move forward. So just make sure that you're putting in a date and a time. It doesn't matter what that time is. It just has to have some information in that field, or otherwise you can't move forward.
Right. So also at the top, you'll see that you have your dashboard. And if you click on your dashboard, it's going to show you all of the forms that you've submitted through this system. And you can filter them by a property address. So if you're a property manager and you have a bunch of different properties, you can say, I just want to look at these. And you'll see that for each form that's identified here, these ones where it says continue are forms that I have started but not finished. So that's an option. When you're starting to register a tenancy, you can start and stop, and it will stay there on your dashboard, and you can go back and finish later. For those that are finished, you'll see that it shows the address of the property that you just registered, and so you can know which form has to do with which unit. Let me just go on to a different one where I might have one that's completed. So here you see one for 1431 Sentinel A that has been submitted. If you click on the hyperlink to the form, it takes you back to what you submitted. And there's also a facsimile of the form that you can download or print, whatever you want to do. So It's convenient, if you have a different way of tracking your property registrations, you have folios for each unit, you can just print the registration form. But it's always here on your dashboard as well. If you go down to the attachments section, these forms, for tenancy registration forms, we leave it open for 1 hour. So in case you realize, no, it's the wrong unit, or I put in the wrong amount, you can edit it and change it. But after 1 hour, the system will generate a form that with all the information that you provided and attach it here. It also gets sent to you by email. So because your CIVICS account, is associated with an email, we'll email you a copy of this form as well. And that's the same with an ownership registration form or a change of mailing or added amenity. We also, in those cases, as soon as you file the form, we send you an email and say, okay, we got it. But the form itself that you that you have registered, you can download. The hyperlink here doesn't really help, but if you can download and save it. So there's also on your dashboard, you'll see that there's a milestone, and that indicates the processing status of the form that you submitted. So let's see if I can find one. Most of them are completed or closed, meaning we've already processed the form. Try to find one that's different. Well, here's one that's different, and you see here it says 1 pending task. So there is a way for us to interact with you if you submit a form and we have some question about it. Like, let's say you said there was parking, but you didn't tell us how many spaces or what type. We can send the form back to you with this question, and you'll get an email. You'll get an email first telling you, hey, can you look at this? So you would go to this, if there's a pending task, you would open up the form, make any adjustments you need to make, and then you digitally re-sign it again, and it sends it right back to us for processing. So this allows us to kind of automate this instead of calling you or emailing you. Well, we do email you. One of the last thing that I'll point out, which is really convenient about having a CIVICS account, is we also put what's called the site master. Let me see if I can find one. So for every property that you say you own or manage, we add the site master to your dashboard, and that link allows you to run. So here's one here. So I click on the hyperlink, and then there's a report section. Because Micah talked about the report of maximum allowable rents that we send to all owners in June, and that tells you what is the current rent for this unit, when was the tenancy started, and that sort of thing. But that's something we only send once a year. You can go to the look up a rent, and it will tell you what is the current rent and what is the tenancy date that we have. But if you go here and you click property summary, the system generates a real-time report of everything that we have for this property. So here we have the ownership information. You can check, okay, is this the right owner? Is this the right mailing address? Is this the right authorized agent I want? Are there any fees or exemptions on this property? Is there a bill due? No, it was paid. And then we have the complete MAR history. So this unit is a long-term tenancy, and you'll see under the amenities, these were all the amenities that were filed by the owner back in 1978, saying this is what this tenancy came with. And then we have the complete MAR history going back in time from the most recent general adjustment, what that general adjustment was, $22, and what the current MAR for that unit is. So this one is not going to have any tenancy on it, but here, this next unit, you can see an X number. This says a new base rent after vacancy. So that means this was the new tenancy here. They're also in the system change. When we adopted this system, we changed the application numbers, so they now say 10 reg or tenancy registration, and that tells you when the last registered tenancy was. It's also available in the summary section, kind of above there. It says this is the MAR for the unit, so this is the maximum lawful rent without the registration fees or the surcharges. And this is the amount to which we add the general adjustments and the tenancy date. So you can see, oh no, I have somebody who moved in 2019. I need to register a new tenancy here. But this is, this report, like I said, you can run it anytime. You go to your, the site master for the property, and under My Documents, there's a link to property summary. And that is real time, whatever we have in our database. And it's a great way to check to see what's on file. So that's it. We're over 5 minutes. Do you have any last questions? Yes, sir.
Most likely use the service, but can we, sorry.
Can we still do hard copy, or is there another option other than this? Although I'll probably go this route.
Yeah. You know, we discourage it because with hard copies, there are issues with data entry. Sometimes, you know, if we have to convert what's on the paper to what's in the system, it's delayed because we don't have the staff to do that. So we're really trying to encourage everybody to do it through this system. Also with paper copies, if there's an error or something like that, we don't have a way to get back to you to like send you an email to say, hey, correct this. You put in a rent of $1. We don't think that's correct. You know, why don't you fix that? You know, so there are advantages to using the system.
Okay, I would like to know what happens to a property that has been landmarked, went out of business through Ellis, and wants to come back in the market, you know, after the 5 years. Can that building be torn down? It has been landmarked.
Well, the landmarks probably does not allow it to be demolished. So if they want to come back into the rental business, that's fine. After 5 years, the owner would be able to charge a market rate for those units. But if there are some tenants who said they wanted to come back, they would have to be offered the units back. But not at market, I mean, not at
the
their
market-
old,
at the market
at the
rate.
new market rate. Yeah.
Still on the additional amenity issue, so let's say you're renting to a tenant for $1,000 a month, you decide to add a garage maybe, and the tenant agrees they would like to have a garage for $200 a month.
Mm-hmm.
Then is that $200 a month considered part of the MAR, or is it separate? So you can't just say, okay, raise the rent on the garage by $30, and
So that gets, that amount for the additional amenity gets combined with the MAR. And then it is increased only by the general adjustments every year, not a separate amount. So you can't say, I'm going to increase the parking by another 50, but otherwise your rent goes up by 3%. So it gets tied together. Yeah.
And that's for post-99 tenants.
That's post-99 tenants, right? Okay, so if you need to review this, we'll put it up on our website as soon as we can get it. But I appreciate you coming, and thanks for your questions. We had a very small audience, but good audience. So, and again, if you have any follow-up questions, just call our office, and you'll be directed to somebody like Micah who can answer your questions.
Thank you both.
Okay?
Evaluation form?
Sure. We have some evaluation forms there in the back if you'd like to fill them out.